We get a lot of calls on a weekly basis from people that have been arrested for DUI, and they ask us, well, I got caught red-handed, I blew, or they took my blood and they know the results are not favorable, they know they looked incredibly impaired, and they're ready to throw in the towel and just fall on the sword. Well, DUI may have a lot of defenses, and the case is not always about what really happened. Often it's a matter of what the state is able to prove in court at the time of hearing or trial. Therefore, it is imperative that as soon as you are charged or believe you may be charged with a DUI, that you contact an experienced DUI defense attorney like us here at Leader and Leader. I've dedicated a great portion of my career to the art of defending and winning DUI defense cases. We can never promise a particular outcome in any given case. However, we will work hard to defend you and fight your case. A lot of clients come in and tell us or call us for a consultation and say, I don't see the point in fighting this. It seems so obvious. I blew, they have my breath reading, I look terrible, they videotaped me, whatever the reasons may be. However, these cases are frequently about what the state can prove in court, not necessarily what actually happened at the time. DUI carries tremendous penalties. There's a mandatory adjudication, meaning a permanent misdemeanor conviction or felony if you're facing a felony DUI. But either way, you're facing a permanent conviction that you can never get rid of and will prevent you from ever sealing or expunging that case or anything else in the state of Florida under the current law. In addition to a permanent conviction, if you plea or are found guilty to a DUI offense, there are a multitude of other statutorily imposed penalties that the court must impose, including substantial fines, court costs, license suspensions, community service, interlock devices, immobilizations of your vehicle, and so on. The penalties in and out of the court system for a DUI conviction can be very serious and impact your life. No matter how bad the facts of your case may seem, there's often defenses. In many cases, we may find defects or problems with the methodology used by law enforcement. There may be problems with how they went about the case or when they detained you or why they stopped you. If we can demonstrate that the initial stop or detention was unlawful, all the other evidence may be subject to being thrown out by the court as a result of the unlawful activity of the police that led to that evidence. In other words, but for them stopping you illegally, they never would have seen the observations that they made had you do roadsides or got the breath test if you gave one. And in that situation, all that evidence may be subject to suppression, preventing the state from being able to move forward with charges and resulting in us being able to get your charges dropped, dismissed, or reduced. It always makes sense to consult an experienced DUI defense lawyer anytime you, a friend, family member, or loved one is or may be facing DUI penalties. In addition to the DUI offense that you have in the criminal court, there's also an administrative process that will result in a suspension of your license. That has to be dealt with within 10 days of your arrest. So there are a lot of aspects to DUI that are incredibly important and need to be timely dealt with. Now, in addition to the technical defenses or the legal defenses dealing with search and seizure issues, or what people refer to as technicalities and I refer to as your constitutional rights, there are a lot of other defenses that we may be able to employ. For example, there are a lot of issues in traffic crash or accident cases that officers have to do different things that they don't have to do in any other type of case. If they don't do those things right, we may be able to use it to your benefit. Also of great importance, do you have medical or health issues? Various medical and health issues can have substantial impact in DUI cases. Whether or not you gave a breath test, had blood drawn, or gave a urine sample, there are procedures that have to be followed, and there's protocols that have to be looked at regarding how the samples were taken, how they were tested, how they were preserved, if at all, and whether the equipment used to get the results were properly maintained and complied with the requirements of law. In DUI cases, there's often defenses related to your medical issues. We've had various clients that have occupations or are on certain medication or have medical problems or ailments that may have affected their case. For example, somebody that is having a diabetic event can give off an odor from their breath that's often confused with the smell of alcohol in somebody's breath. Likewise, somebody that's been awake 17 hours or longer can begin to suffer from signs of sleep deprivation that are often mistaken for the same signs or clues that police officers look for in potential DUI suspects. The bottom line is, in many cases, there are a number of potential defenses depending upon the facts of your case, the individual facts of your situation, your medical issues, your occupation, whether you were in an accident, whether an airbag deployed, the process, and when things happened in your case. There are a myriad of defenses that may be employed to save you from the DUI allegations. In any instance where you are facing a possible or actual DUI charge, it is imperative that you call us immediately to discuss your case so we can help evaluate the best way to defend you and try to protect you from the allegations.